I welcome Dr. Anagha Sarpotdar here today as an expert speaker on sexual harassment of women at the workplace. She is basically a postgraduate in social work from the Institute, Tata Institute of Social Sciences, and even a PhD from our institute, Tata Institute, on sexual harassment of women at workplace. And her aspect of study was socio-legal study of organized sector in Mumbai. She's working on gender-based violence since 1999. She is a consultant on social and legal aspects of sexual harassment at workplace from somewhere from year 2005. She's working on ICCs at various organizations, and she conducts the training on sexual harassment at the workplace for various sectors like corporate, government departments, public sectors, the colleges, the ICC members, the employees, the senior management people also. She's involved in drafting and reviewing the policies regarding sexual harassment of women at the workplace. She has publications on EPW and have authored a document which is titled as Sexual Harassment at the Workplace in India, which was drafted for ILO in year 2009. Currently she is functioning as chairperson of the local committee constituted by the district collector office under the act, that is Sexual Harassment at the Workplace Act, which was of 2013. So we are really lucky to have such an experienced person and an expert on the topic to share the details on this. She will be talking about the act, the provisions, and the other aspects of it, like how it evolved and what are the provisions under that. Along with that, I would also request her to talk about the Shakti bill since she has been working on it. And I really thank her to be here, though she mentioned that she is not that well, but I'm very, it is actually a commitment to the cause that she has been working on that makes her to be here. That's what I think. So really thankful for that. And once again, warm welcome for her to be here with us. And I hand over mic to Dr. Anagha.
Yeah. So thank you, Dr. Sujata. And it's a pleasure to be here. Maybe a few years back, obviously not online, because when I was at TISS, there was nothing online. We were inside the classrooms. So 1999, I passed out from social work. And of course, 2016, I got my PhD degree. I was registered with School of Social Sciences. Some of you may be knowing Dr. Asha Bajpai was my guide. So, you know, it's a wonderful opportunity for me to talk to all of you. I would prefer if at least for, few minutes in the beginning, if everyone switches on their videos so that I know that I'm talking to people and not to boxes. So usually the way I go about is I ask for individual introductions, but we don't really have that kind of time, and I don't think we should get into that. But definitely I would want to know if there are any specific expectations from a session like this. Had it been an in-person session, I might have screened some videos, or we would have done some small exercise of discussing case examples, etc. But I'm not very sure because we are connected virtually, and I don't really want to spend time in adjusting the video and all. Sometimes the technology is a challenge. So I would prefer kind of using a PowerPoint presentation. But as I said, before I start, I want to know if there are any specific expectations from a session like this. Anybody wants to say? Are there any expectations? Are you looking forward to understand any particular aspect of the law? No? Nobody has, does anybody have any exposure to this particular issue or this particular law specifically? Nobody.
No, ma'am, we don't have any exposure.
Okay, fine. I just want to say this, that please ask as many questions as you can, because the more you ask, the more the discussion will kind of flow and progress. And your participation is required. And I'm quite surprised that TIC students are not participating, because I come from a generation where the questions wouldn't just stop coming. But maybe times have changed. So I will start. I will use a PowerPoint presentation, and of course, my camera is going to be off when I'm using the PPT. The other thing is that please excuse me, because I have bad cough and severe throat infection. I'm just recovering. Just bear with me. Give me a second. I will share the presentation. Is it visible to everyone?
Yes, ma'am.
Yeah, it's there.
Yeah, just let me put it in the slideshow mode. Okay, so without wasting much time, or without spending more time on just talking about the issue, what I will do is I will straight talk about the act, because this is a feminist legal studies course, and the focus is on this particular legislation at the moment. While I talk about the legislation, I will also talk about certain challenges, certain issues, and certain things which are related to the act in terms of myths, facts, etc. So this is the title of the act that is there on the slide: Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. Now, as you can see, this law was enforced in 2013. It's a new law. Now, when you look at the title of the act, I'm asking you this question: apart from sexual harassment at workplace, which are the words you think are important? What, according to you, which words are important apart from sexual harassment at workplace?
Ma'am?
Yeah.
Ma'am, prevention and redressal, I think, are two of the focus areas also.
Yeah, so prevention is one, but not redressal, because redressal is something that is, yes, but not really significant, because when the word sexual harassment of women is there, redressal is something which is going to be entailing. But the important word here, prevention is one, yes. And the second word which is important here is women, because this law is only for women. It is a gender specific legislation. Now, we will also look at what is the definition of women. We will also look at, what happens if, individuals who are not women, if they want to complain, etc. Now, let me also tell you that there are separate UGC, there is a separate UGC notification, or there are separate rules for this particular act, but I will not be touching that today because we don't have that kind of time. And as far as I know, the UGC notification is gender neutral. The UGC notification is not restricted to women, but of course that is a separate topic, and whether such a notification which is contradictory with the act, whether it will sustain in the court of law, etc., we don't know. But today I will be focusing on this particular law, and so this is like I'm discussing the BEAR Act with you. So one is, of course, as I said, prevention, and the other one is women. Now, this is just for your information, because when we talk about any legislation which is related to women, we also need to understand the context in which this particular legislation was enacted and enforced in India. So as you can see, September 2012, it was passed by the Lok Sabha. Now, does anybody remember what happened in December 2012? Does anybody remember?
Nirbhaya case.
Yes. So the few months before the Delhi gang rape case, I usually don't use the word Nirbhaya or the term Nirbhaya because that was, I'm not really sure, but so I would prefer to refer to it as a Delhi gang rape case. So the Delhi gang rape case happened a few months after this bill was passed in the Lok Sabha. And then you can, I mean, obviously, because the Delhi gang rape case happened, it was immediately passed by the Rajya Sabha in 2013, because that case happened in December. And 2 months later, it was approved by the Rajya Sabha. And then the President of India has given his approval or assent in April 2013. So all these things have happened one after the other, but you see that there is a gap between the President giving the assent to the bill and it becoming an act, and then the act coming into force. So the act has come into force only in December 2013. So there is a gap of several months. Now, one does not really know the reason, but apparently we were told that the rules under the act were not drafted, and therefore the act was not enforced immediately. But what led to the act getting enforced? So there is another landmark case which happened in November 13. Has anybody heard about the Tehelka case? Have you heard of the Tehelka case? Do you know what it is about? Yes or no?
They might not be known.
No, have they heard? It's okay even if they don't know, but has anybody heard?
It has been the
Yes, ma'am.
sexual assault case against Tejpal.
Yeah. So the Tehelka case is basically a case of sexual assault, and it happened between Tarun Tejpal, who was the founder of Tehelka. So what is Tehelka? Tehelka is a magazine that does investigative journalism, and Tarun Tejpal was accused of sexual assault by a junior woman reporter who was obviously younger to him, much younger to him in age and experience, position, because Tarun, and all these things are very important when we talk about workplace sexual harassment, because workplace sexual harassment is all about power. And this power is to do with the power of experience, power of age, power of position. So there are various forms of power that are associated with most complaints of sexual harassment, and even with Tehelka. So the Tehelka case happened in November. So it was reported basically. So she reported the incident in November because the incident happened in November 2013. Now, this particular case is also very important from the point of view of the definition of workplace, because we are talking about sexual harassment that is happening in the context of workplace. So what is workplace? Workplace, or what is so for all of you, if you are receiving education in a particular institution, or you are students of an institution, it is not a workplace for you, but it is a place where you are engaged for some academic activity. So what is that place? Is that place only a geographical location? So say if you are out for a field trip, if you are out for field work, like, so women's studies, I don't know, may not be having field work, but do you have field work? You have.
Yeah.
So if you are out for field work, if you are out for some exposure trip, if you are out for, any activity which is related to your academic course, then is it not important? Is it only important if you are at TISS? So I'm just drawing a kind of a parallel between the Tehelka case and your situation at the moment. So what is the definition of workplace, or what is the definition of say any location where sexual, where if the sexual harassment happens, is it required that the woman is at that particular location, or can she be anywhere else for that activity? So this particular case of Tehelka is important from various points of view. Now, without going into too many details of the Tehelka case, I just want to say that when this case was reported, Tehelka did not have a complaint mechanism. So all of you must be knowing that every workplace, every educational institution, every university should have a complaint mechanism, which in the form of a committee. So it may be called as an internal committee, it may be called as a posh committee, it may be called as a cash committee. There are various nomenclatures, but Tehelka did not have an internal committee in place, and in fact they refused to constitute a committee, saying that this is our internal matter and we will not constitute a committee. And then the complainant approached the police. She registered an FIR with Goa police, because as I said earlier, the Tehelka office is at Delhi, but the incident happened somewhere else. So the incident happened inside the elevator of a 5-star hotel at Goa, where Tehelka was having its event. So they had an event, and that event was at the 5-star hotel. I don't remember the name of the hotel, but it's a 5-star hotel, and inside the elevator, the incident had supposedly happened. So then the complainant registered a police complaint, and the trial for the sexual assault went on for about 7 to 8 years. And last year, that is 2021, I think it was April or May, the criminal court came out with their verdict, came out with their judgment, and Tarun Tejpal was found not guilty. Now, this was a big setback, because there were so many so many aspects which were very clearly indicating that the sexual assault had happened. But then the criminal court did not take those things into account. Like, for example, after the incident was reported, Tarun Tejpal had written an apology letter to the complainant, but that apology letter was discarded by the court, saying that he might have written it under pressure, and that was not really taken into account by the judge, because the standard for a criminal case is different. I will not go into that at the moment, but the point that I'm trying to, so why am I telling you about the Delhi gang rape case? Why am I telling you about the Tehelka case? Is to make you understand that this law, this workplace sexual harassment law, has not, it has not kind of come in isolation. It is there are multiple high profile cases which surround this particular legislation, and we have to always understand that all these legislations related to women, related to children, related to various marginalized groups, they are never enacted and enforced in isolation. There are certain conditions in the society, which is why they are brought into existence. And I just gave you few examples. I'm sure there are many other cases which I may not be aware of. I just spoke about two cases which are, which were published in the media. So 9 December 2013, the law was enforced. When I say law was enforced, what is the meaning? That the law became applicable. So it was already enacted, but it became applicable only in December 13. Now, it is very important for us to look at the objectives of the Act, because whenever we are looking at any law, what is important for us? The most important thing in any law is to look at the objectives. So here the objective is to prevent and redress sexual harassment happening to women. Now, protection is slightly, it's an outdated concept, and we don't really require any protection from anyone. As women, what we need is that our rights, our right to work with dignity, and our right to safe workplace are preserved. But then that is the legal language, and that is the government language, and government will always come from a position that we are protecting women. So that is why the word protection is there. But basically the law aims at preventing and redressing sexual harassment. Now we are getting into a very important area, wherein we are now looking at the key features of the Act. So what is this Act all about? So all of us know about the committee. All of us know that whenever there is a case, whenever there is a complaint, there will be an inquiry, etc. So some of us might be knowing about it. TISS also has a committee. All universities have a committee. But this committee business, or rather, where has this law come from? What is the starting point? Did the government of India suddenly wake up in 2013 and say that, let's have a law on sexual harassment? No, that was not the case. And that is why we have to understand that this is a social legislation. What is the meaning of a social legislation? A social legislation is a legislation or a statute or a piece of law, or rather an act, which comes into existence because of certain conditions in the society, because of the status of women. Now, this particular law, if we trace the background, we have to go back to the Bhateri Devi case. So this particular case happened somewhere in the 90s. So about 30 years back, this case happened in Rajasthan. And this is also known as the Bhateri gang rape case. So some of you may not want to name the complainant or name the rape survivor. So we sometimes alternatively also call it as the Bhateri gang rape case. Now this Bhateri village is about 50 to 60 kilometers away from Jaipur. And the reason why I'm telling you the distance is just for you to understand that it is not a remote location. And this Bhateri Devi, on whose shoulders this act is resting, she was working as a volunteer. So she was working as a Sathin. So she was working as a village level volunteer or village level worker with the government of Rajasthan. And government of Rajasthan was the employer. See, because we are talking about workplace sexual harassment, the role of employer is very, very important. So Bhateri Devi actually that year the government of Rajasthan declared that they would have they would observe anti-child marriage fortnight 15 days before Akha Teej. So Akha Teej is the word used in North India. In Maharashtra we use the word Akshay Tritiya. I don't know what is the word which is used in southern part of India, but it is basically an auspicious day on which mass child marriages happen in Rajasthan. And that was the year, I think it was 1992, when the government of Rajasthan declared that, look, this year we have these village level women working with us as volunteers and they are paid honorarium. See, this is very, very important because Bhateri Devi was not an on-roll employee of the government. She was on contract and she was paid honorarium. Now, all these things are very important from the workplace sexual harassment point of view because she was not a permanent employee. Now, the government told all these women that if there is a child marriage happening in your village, you report to us. And Bhateri Devi reported one such child marriage that was about to happen in the Gujjar family. So Gujjar is a dominant caste in Rajasthan. It's a landowning community. So Bhateri Devi belonged to the Potter community and the Gujjars were hierarchically above her. Both of them fell into the category of OBC. And why I'm telling you this, because caste is very, very important in this case, because though both of them were in the OBC category, Bhateri Devi was hierarchically lower than the Gujjars. And because she reported the child marriage that was to happen in a Gujjar family, the entire village was angry with her because she had challenged the age-old tradition of child marriage. And they said that, this woman is actually doing something, she's insulting the village, she is not respecting the Indian tradition of child marriage, etc. So this case is not just about gender, but it is also about caste, it is also about class, because Bhateri Devi was also coming from a poor family compared to the rapists who were from a landowning family. Now, after she tried to stop the child marriage by reporting it to the government, nothing happened. The child marriage still went ahead. It was between a 1-year-old boy and 9 months old girl. They were to be married. After the marriage happened, Bhateri Devi was gang raped. So she was first socially boycotted and then she was gang raped by men from that family where the marriage had happened, and one more man from the village. So about 4 to 5 men had gang raped her. And where this rape happened, did it happen inside the government, Rajasthan government building? What is the definition of workplace? No, the rape happened out in the open when Bhateri Devi was collecting firewood with her husband. So the again, the definition of workplace is coming here, that though Bhateri Devi was employed by the government on contract, she was gang raped when she was out in the open. So after she was gang raped, there was a huge struggle for registering FIR, and again the rape trial happened in the sessions court, and the judge acquitted the rapists by saying that upper caste people do not even touch people from the lower caste, so rape must not have happened. And also the judge also said that it is not possible for a woman to be raped in the presence of her husband, because what was the husband doing? So it was a regressive judgment that was given by the sessions court. And after this judgment came, there was a public interest litigation in the Supreme Court of India by Vishakha and others. So Vishakha is the name of an NGO or a non-profit or a women's group or a women's organization. Now it must be organization. That time it was just a women's group, and it was led by, so the name given was Vishakha. So they filed a public interest litigation in the Supreme Court of India. Vishakha and others, so others were women's organizations like Jaguri, Sakshi, etc., who are at Delhi. And they filed a public interest litigation saying that what is the responsibility of the employer whenever an employee is sexually assaulted? Because Bhateri Devi had reported to the government of Rajasthan that she was being sexually harassed, she was being socially boycotted by the villagers, which finally culminated into rape. But the Rajasthan government had actually not taken any steps to protect her. So that was the prayer. And after the public interest litigation was filed, the Supreme Court gave a judgment in the year 1997, where the Supreme Court said that it is the sole responsibility of the employer or it is the sole responsibility of the institution. So if you are a student and you are studying in an institution, it is the sole responsibility of the institution to protect the employee or the student from sexual harassment. So the entire focus is on the employer. For the first time, sexual harassment was recognized as a misconduct. There was a definition of sexual harassment. There was an internal mechanism that the court suggested for redressal of sexual harassment. So this is the significance of the Vishakha judgment, because if Bhateri Devi would not have fought hard, and if the women's movement would not have kind of, along with her fought it out, then we would not have this workplace sexual harassment law today. Now, the second feature that we are looking at is that it's a special legislation. So what is a special legislation? See, many people tell me that this law is only for women. So the law is unconstitutional because it is leaving out men. But we need to understand that the Article 15(3) of the Indian Constitution allows the government to enact special laws for women and children. So it says that nothing stops, nothing shall prevent the state from making special provisions for women and children. So that is how we have the law on child sexual abuse, that is POCSO. We have the Domestic Violence Act for women. We have this workplace sexual harassment law for women. These are all gender specific legislations because the Constitution of India allows the government to enact special laws for women and children. Now, coming to this whole thing of gender specific legislation. So who are women? When we say that women, who are women? Are women only those individuals who are maybe born with biological characteristics of females, or there are certain other individuals who may also be identifying themselves as women? So we have to understand that as per the NALSA judgment given by the Supreme Court in 2014, the Supreme Court has very clearly said that if a transgender person, or rather this NALSA judgment gives transgenders right to self-identity. So if a transgender person identifies themselves as a transgender woman, then they will also be they will be included in the category of women. And if such a person complains, then of course the internal committee will have to look at their case. The internal committee cannot say that you are not a woman or you're not a person born with female characteristics or sex assigned at birth is not female, so we will not look at your case. So that is one. Even trans women, so there may be certain individuals who may have undergone surgical interventions, and they have changed their physical characteristics, and they are they identify themselves as trans women. So trans women will also be included in the category of women. So it is not just that persons who are biologically born as women or with female characteristics are women, but there are certain there may be many other categories, but I'm not getting into the details in the interest of time. So now then what happens? So this is about a group of persons who may fall in the category of women. But what about others? So if men want to complain, or individuals who are not women or who don't identify as women, if they want to complain, what happens? So as I told you, the UGC rules say that anybody can complain. So it is the rules are gender neutral. What is the meaning of gender neutral? That the category of complainant is gender neutral. See, the category of complainant in the law is gender specific. It includes only women, but the UGC rules make it gender neutral. Many organizations, private sector organizations, or whom we call as corporates also have gender neutral policies. So these policies allow everyone to complain irrespective of their biological or sex identity or their gender identity. So any person who may be gender fluid, who may not be ascribing to any one particular gender, all of them can complain. Yeah, I see a hand.
I just wanted to ask, when you say UGC, it's University Grant Commission here, right?
Yeah.
So what about so the government itself does not see it as a gender neutral law, it is just corporates and UGC?
So corporates and UGC, so any organization internally can have a gender neutral policy, but see, the problem here is that UGC being a government body, we don't know whether a gender neutral, gender neutral rules will sustain in the court of law. We don't know. Nobody has challenged the UGC rules in the court of law, but government organizations, and when I say government organizations, I'm not only talking about UGC. I'm talking about all the government departments. I'm talking about all the public sector undertakings. I'm talking about all the government offices. If they are having gender neutral rules, or if they're having gender neutral policies, I really don't know whether they will sustain in the court of law. So what you're saying is correct, that at one hand, on one hand, the law which is drafted by the government of India is gender specific, and then whether government organizations like UGC, can they make it gender neutral? So that is something which is debatable, and we don't know whether it will sustain in the court of law. But as far as the private sector is concerned, yes, it will sustain, because any private organization has a right to have its own policy, and they are not restricting the scope of the policy. They are expanding it to include more people. And again, I am not I'm not taking any position here, as in I am not in the favor of gender neutral policy or something, or neither I'm saying it should be gender specific. It really depends upon the situation, but we have to understand that the law is gender specific, and a gender neutral policy does not mean that everything in the law is going to be applicable. So we have to also understand that difference. Gender neutral policies have to be drafted carefully, because then if you have men complaining, we also have to understand how the power dynamics between men and women will become operational. So anyway, that's a separate topic. The last point on the slide is that this is a civil law. So what is a civil law? See, a civil law is basically a law which is basically, so to define it in a very simple manner, a civil law is basically a law which is between two individuals, where the complainant is complaining about the respondent, and it is not, she's not going to the police, she's not registering an FIR. So this is a civil law, and the complaint goes to the internal committee. What is the difference between a civil law and a criminal law? So under the criminal law, sexual harassment is a crime. So section 354A of the Indian Penal Code makes it a crime. So if I want to register, if somebody touches me, if I am in the market and somebody has grabbed my breast, and I want to complain, I will go to the police and I will complain under the Indian Penal Code, section 354A. There are various sections, A, B, C, D, E, and all these sections have come after the Delhi gang rape case. They are a result of the criminal law amendments. So I can complain to police. But at the same time, if so market is a wrong example. Maybe if I'm in a mall and if I'm molested by somebody, I have an option to go to the police, but at the same time I have an option to go to the committee of that particular say cinema hall, or it may be a mall, or it may be a bank. I may be a customer and I may have gone to the bank and somebody has done something to me. So I have both options. I can go to the police. I can also go to the internal committee of that organization. And this law that we are talking about right now is a civil law. So we are, the internal committees are not police. So please remember that women always have an option to go to the police or to go to the internal committee. I'm not going into the case laws at the moment. The last the last feature of this act is this is a beneficial legislation. See, we are covering this topic in the feminist legal studies course, and what is very important about this law is that whenever this law is operational, when I say law is operational, what I mean is whenever we are implementing the provisions of this law, whenever we are interpreting this law, what is the meaning of interpreting? Whenever we are reading the sections of the act, all of them have to be, all this has to be done in a way which is beneficial to women. I'll give you an example. See, this act says that women have, so today if the incident of sexual harassment happens, women have 3 months to complain. So we are in February, March, April, May. So I can complain till May 2022. But what happens if I'm not able to complain? See, sexual harassment is a very complex issue. I may not have the support of my parents. My husband may not support me. My boyfriend may tell me that I will call off this relationship if you complain. Why that man is only harassing you? Why is he not harassing other girls? You know, there are so many things which are there which prevent women from complaining. Women may not be confident. Women may be scared of losing job. Women, if you're a student, you may be scared that your career, your marks, your grades are affected. So there are so many reasons why women are not able to complain. And does it mean that if I am not able to complain till May 22, my case will not be handled? No. So the law very clearly says is that I have another 3 months. The delay can be condoned by another 3 months. And so May, June, July, August. So I have this gap. I have this, this margin till August. And even if I complain after August, my complaint cannot be dismissed by the institution, or it cannot be dismissed by the committee because because of the reason that this is a beneficial legislation. And under the beneficial legislation, what is important is the spirit of the law and not the letter of the law. What is the letter of the law? The letter of the law means what is actually printed in black letters on a white paper. But what is the spirit of the law? The spirit of the law is basically what is the objective? Why this law has come into existence? It has come into existence because women are on a daily basis facing sexual harassment, and they are in a very difficult situation because they are not able to complain. They cannot talk about it. And now if we are going to dismiss their cases because the complaint was delayed, then it defeats the purpose of the law. And that is why the spirit of the law is important. And when we are talking about these beneficial legislations, like the Workplace Sexual Harassment Law or the Domestic Violence Act, or say, there are many other acts also which protect women, like the Maternity Benefit Act. The spirit of the law is important, and we should not get into the technicalities, but we should look at the, what is in the best interest of the woman. Any questions so far? No questions. Everybody has understood everything, right? Yeah, somebody has raised hand.
Muskan and then Shruti.
Yeah, please go ahead.
I was just wondering, why have that 3-month time limit then at all?
Yeah, so that is, the patriarchal elements will still creep in. So much as we try to have a feminist kind of a legislation, you will nonetheless see some patriarchal elements creeping in, because the government wants to be legally correct, etc. And there is always a fear that, you know, women, अरे, you know, these women, ये तो मतलब कभी भी आ जाएंगे कंप्लेंट लेके, तो हम क्या इनका कंप्लेंट 10 साल बाद भी लेके बैठेंगे क्या? So, you know, the basic disbelief in women. So these are the reasons. But actually, after the Me Too campaign happened in 2018 in India, there was a recommendation that this 3 months bar has to be struck off. We don't know what is happening, because Maneka Gandhi had actually formed a group of ministers, and they had recommended certain changes to this law. But then in 2019, after 2019 general elections, Maneka Gandhi was not given this portfolio. Smriti Irani came, and Smriti Irani is now the minister, and she said that this law does not require any changes. So it is all basically at that level where, you know, one has to have a dialogue with the government of India, but I doubt whether that will happen.
I also have a follow-up. Just so does a situation arise where the court, or they, like, because it has they stick to the 3-month ruling?
No,
and
no,
they-
no. No,
nothing
no,
like
no,
that?
no. Courts will always say that whenever the woman comes, you have to take the complaint.
Okay. Thank you.
Yeah. Courts have been quite liberal in their interpretation. Thankfully, there are very few judgments which are bad, but most judgments by courts on sexual harassment have been good. Most, huh?
And
Yeah.
corporates? Sorry, I'm so sorry. But what about corporates? Is it
No,
the same?
corporates, it depends upon the external member in the internal committee. So if the external member is good, the external member will tell the corporate that whenever the woman comes, you have to take the complaint. They will go by what the external expert will tell them. If you have a bad external member, then they may tell the corporate that, no, this is exceeding the time limit, so dismiss, etc. So that is why we have to be very, very important. I have given you an article which I have written on the Live Law website on the external member. See, all of you, after you pass out, if you do not pursue, I mean, you know, some of you may pursue PhD and you may get into academics, but even after you get into academics, but those of you who continue to be practitioners, you might be invited to become external members with these internal committees because you're women studies graduates. And there, you know, your role is very important as external members. What are you going to do? Are you going to sit there and say that, you know, no, this is the letter of the law and we cannot go against the letter of the law? Or are you going to look at the realities of women and say that, you know, it's so difficult for women to complain, we cannot have this kind of a restriction? So please read that article. I have written about the evolution of the external members provision. Anyway, I need to finish on time, so I will proceed. Is there any other question? There were 2 hands, right?
Shruti?
You had a question?
Yes, ma'am, I had a question.
Yeah.
I had 2 questions.
Yeah.
One, you mentioned in the beginning something about the language of the law, especially around this subject, is comes from
Protectionist.
comes from a protectionist perspective. And from what we have been doing in this class for a while, and then from previous lessons also, there's this idea that women should have implicit trust in institutions to protect them, right?
Yeah. No, and why?
Does so like my question is that, like, doesn't this, like, implicit trust, so this belief that you should come to us if you have a problem and we will protect you, does it not sort of place too much power into the hands of the institutions that are run by men?
Yeah, of course. No, yeah, and this is, of course, the second point. But the first point is that why do you need to protect women? in the first place. Because while we are talking about empowering women, while we are talking about while we are talking about certain things like so again I will repeat the same word. When we are talking about empowerment, we are talking about redistribution of power, etc. Then why do we want to protect women? Why cannot we empower women to see? It is not just it is a deeper issue, because it is also about the diversity in organizations. What is the number of women you have?
And also, does this protectionist language also extend over like so it's there for women, but I'm guessing that it also extends over to across caste barriers and across.
And so it also kind of infantilizes women.
Yeah.
That women are these small little creatures, sweet little creatures who have to be protected by men. So there can be multiple critiques. I agree with you. So I will not dwell on this more, because I agree with you. I have a problem with that language, but we have to work with it, because ultimately, when you're working as a practitioner, or you're working as a researcher, you can only critique it, and of course have a dialogue with the government to kind of maybe over a period of time change the language. But it's very, very difficult, let me tell you. I just want to briefly cover the definitions in the Act. The first definition is that of the complainant. So the word that is used here is again aggrieved woman. So what it means is, the complainant, it's like pidit. So if you translate it in Hindi or Marathi, it's like shikayat karta mahila or pidit mahila or whatever it may be. And there is an assumption that she has a grievance. And who is this woman? Who can complain? So the law says that she could be anybody. It is not necessary that she has to be an employee. See, whenever we talk about a workplace sexual harassment law, there is an assumption that it is for employees. But this law is not only for employees. This law is for any woman who is related to the workplace. So she could be a visitor. She could be working on contract. She could be she could be related to somebody, and she may be visiting the workplace. She may be a consultant. She may be a customer. She may be a client. She could be anybody. But her relation to the workplace has to be established, which is why I was giving you those examples that if I go to the bank and something happens to me there, or if I go to some other university, like all of you are here at TISS, if you are visiting some other university for academic reasons, for research, or it could be an exchange program, if you are maybe visiting another agency for field work and something happens there, so you can always complain to those institutions, though you are not their student, or if the woman is not working there, but still the woman can complain. So this is a broad definition, and it is actually bringing into its fold many women who are coming in contact with the workplace. Now, this particular law also includes the dwelling place. So it is recognizing your homes as workplace, and therefore domestic workers who are working at your houses, they can also complain. Where will they complain? They will complain to the local committee. So every organization which has 10 or more than 10 employees is supposed to constitute an internal committee. Those organizations which have less than 10 employees, they do not have an internal committee. Or those are, like places like dwelling place. So how can you have an internal committee there? So all these, women who are working with units having less than 10 employees, or if they are domestic workers, they can go to the local committee. And these local committees are constituted by the district collector at each district. Now, I am at Mumbai, so I am giving this example of Mumbai. So Mumbai has two districts, Mumbai city and Mumbai suburbs. So we have two local committees here. So domestic workers can come to us. Women who are working with units having less than 10 employees can come to us and complain. And Sujata has already, while introducing me, told you that I am heading the local committee for Mumbai city. So Mumbai city is a small district compared to Mumbai suburbs, and I am heading the local committee. So domestic workers can come to the committee and register their complaints. But the problem here is that domestic workers have no information. The awareness level is low. The local committees are not able to conduct awareness sessions because there is no money coming from the central government. So this local committees actually have no publicity. So that is the problem. Now, the second definition is that of the respondent. So who is the respondent? Respondent is any person. So when we say person, what is the legal interpretation? Person is any person. It could be a man, woman. It could be a person who identifies themselves as transgender. It could be any person who may not identify themselves as a man or a woman, non-binary. It could be anybody. The woman can complain against any person. Now, the critique here was that, are we pitching women against women? Are we, saying that, are we kind of trying, are we saying that, are we perpetuating this whole thing that women are enemies of women, etc.? But, theoretically that may hold, but practically I have seen that due to the influence of patriarchy, due to certain certain way of socialization, women have also aided and abetted sexual harassment. So women have also used abusive language. Women have also help the man to harass the other woman. And of course, this is all a result of patriarchal socialization. And this is all also a result of the power dynamics which exist at the workplace, because the man is in a power position. And of course, women who are helping him are simply, giving in to him because he's on a power position. But basically, this law allows women to complain against women, and that is what we have to understand and remember. The third definition is that, see, the entire definition is not on the slide. What the law is saying is that what is a workplace? Now, we have spoken about the workplace when we discussed the Bhateri Devi case, when we discussed Tehelka case, and I had posed this question that is workplace a geographical location? So if I am a Tehelka employee and Tehelka office is in Delhi, or if I am Bhateri Devi and I am employed by government of Rajasthan, so is it necessary that I am sexually harassed only inside the government building? No. So the law says that wherever I go in the context of work while fulfilling professional duties becomes my workplace. So the law is bringing into existence the concept of extended workplace or notional workplace, and the workplace is not restricted to a geographical location. Wherever the woman goes in the context of work while fulfilling her professional duties becomes her workplace. So she may be out for a research. She may. I will take your question. Let me just finish this. So she may be out for work. She may be out for research. She may be out for a meeting. She may be out for a conference. She may be out for a training. There could be even the people may be out for some pleasure. So they may be out for, say, watching a movie. They may be out for lunch, dinner, or they may be out. People may go for a picnic, and nothing is in personal capacity here. So if you know each other because you are students of an institution, if you know each other because you are employees of an institution, then there is nothing like personal capacity. And if there is any incident of sexual harassment, it will come to the committee, and the committee will have to take cognizance of it. What was your question?
My question was, so there are already laws in place that make sexual assault, rape, sexual harassment illegal in general, right? Like they're punishable offenses in general. What is the specific use of defining these like specific, like the idea defining specifically workplace, defining specifically?
No, because the laws that you're talking about are criminal laws. They do not have definitions of workplace sexual harassment. See, the other thing is, what is so special about Vishakha, or what is special about a civil law on workplace sexual harassment? See, because women, criminal laws are very harsh, and the criminal justice system is a very tough system. As I told you, the Tehelka rape trial went on for 7 or 8 years. Probably, if it would have been handled by an internal committee, then now the internal committee has a limit of 90 days. So the inquiry is time bound, whereas a rape trial will go on for a number of years. So I am actually not pitching criminal law versus civil law, because each has its own merits and demerits. But the point I'm trying to make here is that women should have a choice. If women do not want to go to the police, if women do not want to take resort to the criminal justice system, which is extremely harsh. If you see the movie Bhavandar, which is based on Bhauri Devi's rape case, where Nandita Das has played the role of Bhauri Devi and Raghuveer Yadav has played the role of her husband. The rape trial is actually enacted there, and you will see that the defense lawyer is asking questions to Bhauri Devi that, at some point you must have enjoyed, the men raping you, or did you reach orgasm, etc. So this is the kind of humiliation, this is the kind of intimidation, this is the kind of harshness, and this is a kind of slandering. And at the end of it, Bhauri Devi was also shown to be a woman having bad character. So these are the problems with a criminal trial and criminal law. So if a woman does not want, even in Tehelka, forget about Bhauri Devi, even Tehelka judgment which came last year, the judge has said that she is not behaving like a rape victim. She is, smiling, laughing, and she, there are records that she had multiple relationships, and therefore she's not an ideal rape victim, etc. So if a woman does not want to get into the criminal justice system redressal, what is the option that she has? Does she have an option which is inside the organization? Does she have an option where she can have a dialogue? See, women cannot have dialogue with the police, or women cannot have dialogue with the public prosecutor, but women can have dialogue with the internal committee, because the internal committee is consisting of majority of women, and there is also an external member like people like us. So women can talk to us openly, and they can trust us. So, I mean, obviously, this is the ideal picture that I'm giving you.
Ma'am?
Not all committees are, 1 second, let me finish. Not all committees are good, but that is the purpose why we have a civil law in place. Before
Anagha,
yeah.
Anagha, I just wanted to add to what you were saying.
Yeah.
Was one more thing was about this law makes a responsibility of employer.
Yeah.
Whereas in a criminal case, it would be like I've been some affected thing, or I have some problem, I go to the police and make a complaint.
Yeah.
And it is against the state. But the thing is here, the very difference is it's a responsibility of an employer. So employer has been considered to be responsible person, or like the thing, to make that the women will have a proper atmosphere at work.
Yeah.
So
The law is placing, like Sujata said, the law is placing responsibility on the employer to make the workplace friendly, make the workplace conducive for work. I just want to add to this definition that transportation is also seen as the workplace, because if the institution or the organization is providing transport, then that is also seen as a part of the workplace. So if the if the education institution has a pickup drop service, or if the organization has a pickup drop service, etc., that there the safety. So it is not that, okay, when you're inside the office, the employer is responsible. The employer is responsible even if you are in the company or the organization or the institution transport, even if you are anywhere related to the work. So as I said, it is not necessary that you have to be at a geographical location. Wherever you go in the context of work, while fulfilling your professional duties, becomes your workplace. So there are multiple case laws which are there are multiple case laws which are there, but I'm not getting into them.
Ma'am, before we move on, I had a follow-up to that.
Yeah.
So you said that the reason why these are civil law is because the criminal justice system is very harsh and very difficult, and women should have a second recourse to go to that's less taxing on them. Along those same lines, wouldn't the punishment for such a crime, even though it's as bad as as the sort of criminal, going against the criminal law, because it is a civil law that is being violated, wouldn't the punishment also be lesser, even though the crime is the same?
No. So see, first of all, the woman has to make a choice, and it has to be an informed choice, because if the woman is going under the civil law, then obviously and it is not penalty, it is not punishment under the civil law. The word used is penalty. So the maximum penalty is, of course, termination from service. But we have to also remember that the law empowers the employer to register a criminal case on behalf of the woman if the perpetrator is an outsider, or if the perpetrator is an insider. Then of course the employer can help the woman to register a police complaint. So in a way, we see that the law is actually, placing all the responsibility on the employer for, giving a woman relief. So the employer is not just appointing an internal committee to conduct inquiry, but if the woman wants to go to the police, there also the employer is supposed to provide assistance to her. But it is up to the woman to make the choice whether she wants to get into the criminal FIR mode, or whether she wants to approach the internal committee. Many women do both, because they think that the employer will also punish the person, and there will be a punishment from the state. That is the because a criminal case is the individual versus the state. So there the state will also punish the person for committing crime. So it is for the woman to make the choice. Of course, she has to, the choice has to be informed, and the internal committee will help her to make that choice by giving her that information. So we are on the last definition of sexual harassment. This is one of the good definitions, because this definition is coming from CEDAW, which is the international instrument. This is not drafted by the Indian lawmakers. Now, what it says is includes. See, this definition is inclusive, because this definition is not restricting the forms of sexual harassment to point number 1, 2, 3, 4, 5. It says that there can be many other forms of sexual harassment. As times change, the forms of sexual harassment also change. So the definition is not exhaustive. It is an inclusive definition, and it can include many other forms of sexual harassment which are not explicitly written in the definition. Please remember this all the time. Now, the definition also says that one or following unwelcome acts or behavior. Now, what is unwelcome, and who decides what is unwelcome, and how does a person decide what is welcome or unwelcome to them? So it is, of course, and what is unwelcome? So to begin with, unwelcome is any behavior which the woman is not, it is not acceptable to her. She does not like it. She is basically uncomfortable with that behavior. Now, who decides what is unwelcome? It is the woman who decides what is unwelcome. Nobody can tell the woman that, you come from a conservative family. So, it is a culture. It is our culture to hug each other. It is our culture, to use profanity. Nobody can tell the woman that, this is not sexual harassment. If the behavior is sexual in nature, see the last two words of the definition. The behavior has to be sexual in nature, and if the woman is uncomfortable with any such behavior, nobody can tell the woman that she is she is wrong in complaining. She can complain irrespective of the fact whether she is whether the culture of the organization is like that, or whether, see, here the intention impact thing also comes. What is important in sexual harassment? Intention of the doer or impact on the receiver. So as per law, intention is a state of mind. So if I am touching somebody, nobody knows what is my intention. Nobody can enter my mind. So in Rupan Deval Bajaj versus KPS Gill, the Supreme Court has very clearly said that intention is a state of mind, and therefore nobody knows what is the intention of the person. What is seen is the act. So the act of touching and the impact on the complainant. So if the complainant feels uncomfortable, if the woman feels uncomfortable, or if we are talking about a gender neutral policy, if that individual feels uncomfortable, then of course it is that person can complain. And how does a person decide what is welcome or unwelcome to them? See, the concept here which we need to understand is the concept of personal boundary. So every person has a comfort zone, every person has their own personal space, and anytime if other person tries to do something which gives that person a feeling that this other person is trying to transgress my personal boundary. So if somebody just comes and forcibly shakes hands with me, if somebody tells me that my the shape of my body is ugly, somebody tells me that I look sexy, by using the word sexy, that I look sexy in a particular outfit, and that creates discomfort in me, and I feel that my I'm not comfortable with this comment because I don't have rapport with that person, or I am not I do not really think that that person should talk to me like this, etc. That is the feeling I get. The feeling is of discomfort, and that is legally known as sexual harassment. So the entire definition is resting on this concept of unwelcomeness of behavior. And it is very, very important for us to understand concepts like personal boundary. In fact, when we are talking about metaverse, so we know that the next version of the internet is the metaverse. And recently, there have been reports that in the metaverse version of the reality, women were groped and raped. So Facebook, which was known as Facebook earlier, but now it is known as Meta. So Facebook has created this personal boundary around your virtual avatar. So it is called as the virtual avatar, and there is a personal boundary around it. So you can read it up, because this is the current discussion and debate which is going on, that that human behavior in reality and in virtual reality also is the same. So women are being gang raped in the virtual reality of metaverse, and what are we going to how are we going to deal with that? But of course that is a step ahead. Now, it says whether directly or by implication. Now, what is the meaning of implication? Implication means suggestive. So if somebody is suggesting something to the woman that, if you make me happy, I will help you grow in this organization. If you come out with me, I will recommend that your salary is increased. So, asking something in return. So that is quid pro quo, this for that. So whether directly or by implication. So sexual harassment is not always direct, but it is also implied. And again, from whose point of view? Complainant's point of view. And intention is not important, but the impact. So many men who come for inquiry before us, they tell the committee that, she is like my sister, wo mere behan jaisi hai. And मैं मेरे बीवी के अलावा मैं हर किसी औरत को माँ बहन के नजर से देखता हूँ, and all rubbish people tell us. But we tell them that if she would have looked at you as her brother, she would have never complained. And doesn't matter whether you are her brother or you are her father or whatever. the personal boundary needs to be respected, and you cannot encroach on somebody, you cannot touch somebody, you cannot make comments which make the other person feel uncomfortable. You have to respect her personal boundary, you have to respect her choice. She goes with that man and she has multiple relationships, but uske saath jati hai to mere saath aane mein kya problem hai, and all these things we get to hear when we sit down for inquiries. So physical contact and advances, so touching or trying to touch, demand or request for sexual favors. So women are so asking for sex or asking for some kind of sexual service, making sexually colored remarks. So commenting on somebody's, so body shaming. Please remember, in India, body shaming is very common. अरे वो तो मोटी है, and वो तो काली है, and ये है, and वो है, and we take great pleasure in commenting on each other's bodies without even realizing that we are shaming the other person. And till the time we are in TISS, it's all fine, but once we are out in the open, then one doesn't know what happens. Also spreading rumors about somebody's character, shaming somebody on the basis of their gender identity, shaming somebody on the basis of their sexual preferences. अरे वो तो गे है और ये है वो है, all that, perpetuating all the biases which exist in the society about homosexuality, or it could be any preference. So all these things, making all these kind of condescending, humiliating remarks, showing pornography is also an offense under the Information Technology Act. So if you are watching porn on your system and it is restricted to you, there is no problem. We are not doing any moral policing. But if you are circulating something and the other person is feeling embarrassed, you are forcing the other person to watch something, of course, yes. Any other unwelcome physical, verbal or non-verbal conduct which is sexual in nature. So this law is not recognizing only physical harassment. See, in Indian society, we are still at a place where people think that usne haath to nahi lagaya na, matlab, he has not touched you, he has not raped you, he has not molested you, what is the big deal? But this law is recognizing staring. The most common form of non-verbal sexual harassment faced by women in India is staring. So the man is staring at the woman from head to toe, or is staring at specific body parts such as breasts, etc. So this is very common, but women do not complain about staring because they think that they have no evidence. And how do I prove to the committee that he was staring at me? Because staring is intangible action. So, all these things are covered by this particular law. Now, last but not the least, I just want to say that every organization has an internal committee, and women can approach the internal committee for complaining, and the internal committee has powers of certain powers of the civil code the committee has, and the committee can actually committee conducts inquiry in reported complaints of sexual harassment, and the committee has powers of recommending penalty. The committee is also responsible for prevention. It is not just that the committee has to do only inquiries, but also the prevention. Now, before we conclude, I just want to take 2 minutes and talk about the Shakti Act. So what is this Shakti Act? See, about 1.5-2 years back, there was a rape in Hyderabad, or somewhere near Hyderabad, and the woman was raped and murdered. that time there was a huge discussion because the police had actually, the police also killed the rapists, supposed rapists. Now we don't know whether they were rapists or that, all that is debatable, but police had actually shot them down. And then there was a discussion in Andhra Pradesh about having a special law on sexual violence. So Andhra Pradesh got a law called, or they drafted a law called Disha Act. And then round about the same time, Maharashtra also had a few rape cases. There was one more case where the woman was actually, she was murdered by her ex-partner, or whatever you may call it, boyfriend, partner, whatever you may call it. But she had walked out of the relationship, etc. And then Maharashtra drafted a law which was similar to the Disha law of Andhra Pradesh, and that was called as a Shakti Act. And this act is state specific. It is not for entire India. It is only for Maharashtra, like Disha is only for Andhra Pradesh. Now, this Shakti Act is a problem because it is just duplication and replication of the already existing criminal provisions in the act. Why do we require, as per my understanding and as per the understanding of the women's movement in Maharashtra, we do not require another act. We already have certain provisions in the criminal law which were introduced after the Delhi gang rape case because of the recommendations by the Verma committee. So you all must be knowing that Justice Verma, who gave the Vishakha judgment in 1997, he was the one who also gave recommendations for changes in the rape law. So one time the rape law was changed at the time of Mathura rape case. Second time it also happened after the Delhi gang rape case as an outcome of the Verma committee recommendations. Now the Shakti Act is problematic because it is providing for death penalty. See, all of you must be aware that the women's movement in India is not in the favor of death penalty. However, severe or however heinous the sexual violence may be, because we believe that death penalty does not stop sexual violence. See, after the Delhi gang rape case, convicts were hanged to death. We have had so many rape cases happening. So death penalty will not stop sexual violence. Also the argument is that the state cannot be given power to murder somebody officially. So that is also an argument. The third argument is that the criminal justice system in India is so inefficient, it is so corrupt that you can never say with confidence that the person that you're hanging, you're giving death penalty is the person who has committed the crime. Because in India, the legal process is so expensive that most rape accused will not be able to afford good lawyers. Only the rich people afford good lawyers, and they will never be given death penalty. If you see the profile of men who have been given death penalty, they are all coming from marginalized communities. They are all coming from not just communities, but also from, it's also a class issue. They are also coming from poor families. So Dhananjay Chatterjee was given death penalty because he supposedly raped and murdered a girl in Kolkata while he was working as a security guard. But people were not confident, even after he was hanged to death, that he was the person who had actually raped her. So that is a problem with death. So there are multiple issues with death penalty. Also, we say that in child sexual abuse, if you have death penalty and if a father is raping a daughter, will the daughter complain? Because the mother and all the relatives will pressurize the girl that your father will be hanged to death. So do not complain. So there will be tremendous pressure on the complainant to not complain. And these are the problems with the criminal law. The second issue that I see in the Shakti Act is that it provides for imprisonment in the case of false complaints. See, this false complaint is a big problem. This workplace sexual harassment law also that I talked about and the Shakti Act, you have this penalty for false complaints. So there is a basic disbelief in women, and the lawmakers think that women are out to misuse the law, and poor men are going to be punished, etc. So even when we do not have any official statistics on what is the percentage of false complaints in rape, in sexual harassment, we still have these very stringent provisions. The Shakti Act says that if the complaint is false, the woman will be imprisoned for 1 to 3 years, and there will be a penalty of 1 lakh or even more than that. Now, who will complain if you have such stringent provisions? The minute the woman will enter the police station, the police will tell her that, look, if your complaint is false, you will go to jail, and the woman will never complain. So this Shakti Act is very problematic, but it was passed, or it was approved by both the houses in Maharashtra, Vidhan Sabha and Vidhan Parishad. And now I think it is currently sent to the President of India for his approval. And I really hope that President of India does not give his approval, because it's a draconian act. So, I will stop here. There are many other things which I could have explained with respect to the workplace sexual harassment law, but in the interest of time, and I understand it is difficult for listeners, or it is difficult for participants to focus for a long time because the session is virtual. I will stop here. If there are any questions, you can always write to me, or you can communicate to Sujata, and Sujata will let me know.
Sure.
Yeah.
Thank you, Anagha. Very exhaustive and like at the same time analytically talking about the law, and like each as we saw even in the personal laws also, there are problems with the language of the law and the approach, or the patriarchal or we did see the protectionalist approach of the government, even through the law and even the redressal mechanism, whatsoever it is. So that same carries also here only. But the best part is to certain extent, the approach and the what you say, like definitions given in an act are little better and are useful for I won't say aggrieved person, but an act saying aggrieved person, so I'm saying aggrieved person. So in that way, I think this act is little a better piece of act, and this is quite a recent act, that way 2013 act, so that could be one of the. This is a recent one, not the earlier one. And I think Anagha had tried to give us very much in detail about what the act means when the terms like a workplace, the complainant or the respondent, and the sexual assault. These are the major terms which are used in the act. We need to know what it means and how widened definition that has the scope that has been given by the act to these terms, to include certain things which otherwise wouldn't have been. And this is a little bit of a civil approach towards the resolution of a problem as such. So, of course, the Shakti Act, it itself also could have taken more than 2 hours, but you have tried to give in nutshell of what it is. I request that the students can go through the bill and the provisions which are there, and then what the points you had said about what you said, I won't say the limitations, or rather disadvantage, or why we are opposing the bill as such, So then you can correlate to that. Just last 2-3 minutes, if anybody has a response, quick response, because we are running short of a time. So if anybody has any question. You did ask in between, but at the end, if you had it, or in the future, as Anagha had already suggested, we can have it through email also, any other queries as such. Once you go through all the readings, I had shared the readings which Anagha, you had given it to me, so I had shared it to this with the students, so students have. Shruti, you have something to ask?
I'm sorry if I'm asking too many questions.
No issues.
Somebody else wants to go ahead. That's also fine.
Right now, I think there's no one.
Okay. There was a point where during the presentation where you mentioned that even though it's aggrieved woman, the complainant can be of any gender. How likely?
No. Complainant cannot be of any gender.
Oh, okay.
Or it can be only woman.
Okay.
Or
Respondent can be a
all in the
person.
category of women.
Okay. So
Under
trans women
the
are
gender
included.
neutral policy, it can be anyone.
Okay. How likely is a sexual assault case against a man, not against a man, by a man? So like that the sexual assault was done to a man. How likely is it to be sort of considered and the person who did it convicted?
No,
Under our current
there are
system.
many complaints. Many men complain of sexual assault, but the assault is usually the perpetuated by. I mean, the complaint is about other men, not by women.
Yeah.
So many men complain about men, and those complaints are dealt not by the committee, because the committee is under the law. So we don't have the power to look into those complaints, but the Human Resources Department or the company set up a special committee, and those complaints are addressed quite effectively.
Is there any prior in our current system of a man accusing a woman of sexual assault and that being, even considered?
Not that I know.
Okay.
I also have comments.
Okay, fine.
Let's wind up. I thank Dr. Anagha being here and sharing her expertise and the experience and the whole thing, making it little clearer to us. And it will be definitely useful for us for getting to know about the Act and the provisions. Once again, thanks to Anagha, and let's await that we may have any other more opportunity to continue sharing with you in future.
So thank you, Sujata. Thank you, TISS, and thank you all of you for listening to me and patiently listening to me and participating. Thank you.
Thank you.